Welcome to part 7 of my free YouTube course about franchise law in Ontario. As we continue learning about Ontario's Arthur Wishart Act, otherwise known as the Franchise Disclosure Act, in this chapter, you'll learn about the franchisee's right to sue the franchisor for damages for misrepresentations or a failure to disclose information. This concept is found at Section 7 of the AWA, and this section of the legislation is divided into 5 subsections. You can see subsection 1 of section 7 on the screen now. You can pause the video here if you want to read it. I'm going to provide a plain language explanation of each subsection instead of just reading the law to you. This subsection gives franchisees the legal right to sue for damages if they suffer a loss because of false or misleading information in the franchisor's disclosure documents, or due to a failure to comply with the disclosure requirements set out in section 5 of the AWA. In plain terms, if a franchisor gives a disclosure document or a statement of material change that contains a misrepresentation, meaning something untrue, misleading, or missing important facts, and the franchisee relies on that information and ends up losing money, the franchisee can take legal action. Similarly, if the franchisor simply fails to follow the rules in Section 5, even if they don't lie, the franchisee still has a right to claim compensation for any resulting financial harm. What's significant here is that the franchisee isn't limited to going after just the franchisor. The law allows the franchisee to sue a wider group of people who were involved in creating, approving, or promoting the franchise sale. This includes the franchisor's agent, any broker who helped market or arrange the franchise deal, any associate of the franchisor, and every person who signed the disclosure document or the statement of material change. This section is designed to reinforce the importance of honesty, transparency, and compliance in the franchising process. If those responsibilities are ignored or breached and the franchisee is harmed as a result, the law provides a clear and direct path to recover damages from all those responsible, not just the company, but also the individuals behind it. Moving on to subsection 2 of section 7 of the Arthur Wishart Act, this part deals with how courts treat the issue of reliance when a franchisor includes false or misleading information in a disclosure document or a statement of material change. In simple terms, the law says that if there is a misrepresentation in the disclosure materials, the franchisee is automatically presumed to have relied on that bad information when they decided to buy the franchise. The franchisee doesn't have to prove that they actually read or were influenced by the specific misrepresentation. The law assumes they were. This is important because in most lawsuits involving misrepresentation, a person normally has to show that they relied on the false statement in order to claim damages. But under this act, the burden is flipped. The franchisee doesn't have to jump through that hoop. Instead, the law makes it easier for franchisees to hold franchisors accountable by removing the need to prove that they relied on the misleading detail. If the disclosure document is flawed and the franchisee went ahead and bought the franchise, the law assumes the misrepresentation played a role in their decision. This automatic or deemed reliance strengthens the franchisee's position in a legal dispute and reinforces the importance of full, honest, and accurate disclosure on the part of the franchisor and anyone else involved in the sales process. Moving on to subsection 3 of section 7 of the AWA, this part focuses on situations where a franchisor fails to comply with the rules about providing a proper statement of material change. In plain language, a statement of material change is meant to update the disclosure document if something important changes after the original disclosure was given, but before the franchise agreement is signed. If the franchisor doesn't provide this update when they should have, and the franchisee goes ahead and buys the franchise anyway, the law assumes that the franchisee relied on the original disclosure document as it was, without knowing about the changes that should have been disclosed. What this means in practice is that the franchisee doesn't have to prove they were misled by the failure to provide the update. The law automatically treats them as if they relied on the outdated or incomplete disclosure document. So, if something material changed, like a new lease being signed, or a change in costs, or a lawsuit against the franchisor, and that change wasn't disclosed, the franchisee can still hold the franchisor liable. This provision helps ensure that franchisors can't avoid responsibility just by staying silent about important changes after delivering the disclosure document. It reinforces the idea that the disclosure process isn't a one-time event, but an ongoing obligation right up until the deal is signed. If a franchisor fails to provide updated, accurate information, they're still on the hook. Moving on to subsection 4 of section 7 of the Arthur Wishart Act, this part sets out a defense that can be used by someone being sued for misrepresentation or failure to disclose. In simple terms, if a franchisee sues the franchisor or anyone else involved in the disclosure process for misrepresentation or non-disclosure, that person can avoid liability if they can prove that the franchisee already knew about the misrepresentation or the material change before agreeing to buy the franchise. This means that even though the law usually assumes the franchisee relied on the faulty information, that assumption can be overturned. But the burden is on the defendant, the franchisor, broker, agent, or whoever is being sued. to show that the franchisee had actual knowledge of the problem and went ahead anyway. If they can prove that the franchisee knew the truth, then the franchisee can't later claim that they were misled. This subsection provides a fair balance. It protects franchisees in most cases by assuming reliance, but it also gives franchisors and others a way to defend themselves when the franchisee was fully informed and decided to proceed regardless. It ensures that the right to sue under this section doesn't become a free pass to back out of a deal that the franchisee knowingly entered into despite being aware of the risks or the inaccuracies. Moving on to subsection 5 of section 7 of the AWA, this provision provides additional defenses for people other than the franchisor, such as agents, brokers, or associates, who are being sued for misrepresentation under this section. It outlines 3 specific scenarios where those individuals can avoid liability if they can prove certain facts. The first scenario, described in Clause A, applies when the person can show that the disclosure document or statement of material change was given to the franchisee without their knowledge or consent. If, for example, someone's name was included or their signature used without them knowing, and as soon as they found out, they immediately sent written notice to the franchisee saying it was done without their approval, then they can escape liability. The key here is acting promptly and in writing once they become aware of the issue. The second defense in Clause B applies when someone initially gave consent to the disclosure document or statement of material change, but later discovered that it contained a misrepresentation. If this person then withdrew their consent before the franchise was purchased and sent a written notice to the franchisee explaining both the withdrawal and the reason for it, they can also be protected from liability. Again, the law rewards people who take timely steps to correct or distance themselves from misinformation. The third and more technical defense, found in Clause C, relates to parts of a disclosure document that rely on the opinions or reports of experts. For example, if the document includes financial projections or legal opinions prepared by a third party, the person being sued can avoid responsibility if they honestly believe that the expert's input was accurate and fairly presented. They must also prove that they had no reasonable grounds to suspect there was any misrepresentation or that the document misrepresented what the expert actually said. This subsection recognizes that people involved in preparing disclosure documents are not automatically liable for everything in them. It gives honest brokers, agents, and other participants a way to defend themselves, especially if they were unaware of the misrepresentation or took clear steps to correct the record once they found out. But to succeed in these defenses, they must act quickly, communicate clearly in writing, and prove that they had no reason to suspect anything was wrong. Now that you know how Section 7 of the AWA works, let's take a look at a real-life case to see this section in action. In this case, a corporation registered under the name 2483038 Ontario Inc., along with Baljit Singh and Kulwinder Singh, entered into a franchise agreement in 2015 with 2082100 Ontario Inc. to operate a Fit for Life restaurant in Oakville. Samuel Davis was the sole officer, director, and shareholder of the franchisor. The plaintiffs eventually closed the restaurant in 2017 and sent a legal notice of rescission, arguing that the franchisor had failed to provide a properly certified disclosure document as required by the Wishart Act. They claimed this failure gave them the right to cancel the agreement and seek reimbursement. As you've learned so far in this course, the law requires a franchisor to provide a disclosure document that includes all material facts, along with a certificate signed by key individuals confirming the document's accuracy. The court found that the franchisor's disclosure was missing a critical element, a signed and dated certificate of disclosure. Although Samuel Davis had signed part of the document, it was not in the correct location, nor did it clearly cover the full contents of the disclosure. The court concluded that this failure amounted to a complete lack of disclosure, triggering the franchisee's right to rescind the agreement within 2 years of signing. Despite the defendant's argument that the plaintiffs had received legal advice, had reviewed the documents, and had not been misled by any content, the court held that the missing certificate was a fatal flaw. The plaintiffs were not required to prove that the defect actually influenced their investment decision. The law's goal is not only to protect franchisees' decision-making, but also to hold franchisors accountable for proper documentation. Because the disclosure certificate serves as a mechanism to attach personal liability and ensure accuracy, its absence invalidated the disclosure. The court also found that Samuel Davis was personally liable as a franchisor's associate. He had signed a portion of the disclosure and made promotional representations about the franchise's quality and success. His involvement in marketing the franchise, combined with his total control over the franchisor company, made him personally responsible under the Wishart Act. Although Davis argued that he was not directly involved in the approval process for the plaintiff's franchise, the court found that his signature and promotional statements constituted sufficient involvement to meet the legal threshold. As a result, the court ordered both the franchisor and Samuel Davis to pay the plaintiffs a total of approximately $476,000. This amount included $200,000 in franchise fees, $45,789 in royalties, $7,000 for inventory, and $223,119 for equipment and leasehold improvements. These were amounts recoverable under subsection 6 of Section 6 of the Arthur Wishart Act. Interest was also awarded. The plaintiffs also sought to recover approximately $148,911 in rent that they had paid directly to the landlord, but since this money had not gone to the franchisor, it was not included in the immediate judgment. However, the plaintiffs were allowed to pursue that amount separately through a court-appointed reference. The franchisor's counterclaim was dismissed. It had argued that the plaintiffs had wrongfully rescinded the agreement and improperly removed restaurant equipment. The court rejected this, finding that the plaintiffs were legally entitled to rescind and were not required to leave behind equipment they had paid for, especially when the franchisor had refused to repurchase it. Other allegations made in the counterclaim, including misrepresentations and operational defaults, were not supported by the evidence. Ultimately, the court concluded that the plaintiffs had lawfully rescinded the agreement due to a fundamental disclosure failure. The franchisor and Samuel Davis were held jointly liable to compensate the plaintiffs, and the franchisor's counterclaim was dismissed entirely. The parties had previously agreed on how legal costs would be handled, and the court enforced that agreement. This case illustrates the strict approach Ontario courts take toward franchise disclosure compliance and the serious consequences of failing to meet even technical requirements. It should also be noted that Samuel Davis appealed the judge's decision to the Court of Appeal for Ontario, which is Ontario's highest court. Suffice to say, his appeal was unsuccessful. Congratulations! You've completed Part 7 of this course about franchise law in Ontario. In the next video, we'll talk about Section 8 of the Arthur Wishart Act, which deals with a concept known as joint and several liability. Don't forget to subscribe. I'm Ryan Keeney, and thanks for watching. I'll see you in the next video.